So therefore, a notification was issued saying that except those appeal which arises from out of an special marriage act shall be before single bench. Now, therefore, I have put this question. If your suit was under special marriage act, it will be presumed that decreased by under the special marriage act. If it is under special marriage act, how an appeal will lie? This will be before I see. Kindly see the notification on the basis of which this has been listed. Read it. In partial modification of registration, Honorable is pleased to allow registry henceforth to list matrimonial appeals matter arising from others and judgments of family courts before special division bench.
And also, madam.
And however, matrimonial appeals matters arising from the orders and judgments of district courts other than family courts may be continued to be listed before a bench of Honorable Single Judge so and so, so and so. Now, your suit is under Special Marriage Act. What will happen then? So, automatically, the decree is under the Special Marriage Act. If decree is under Special Marriage Act, Special Marriage Act specifically provides that appeal shall lie before a division bench.
My lord.
We need a clarification. I'll have to have a talk with
My lord, that's why I've also.
See, we understand. How many special courts are here under Special Marriage Act? No.
My lord, on district court, my lord.
All district courts are might be notified as a special judge under the Special Marriage Act. So therefore, their decree will lie before a division bench. Is that it? So we'll adjourn this matter today. We'll have a clarification from the. Yes, sir. Any government, can you enlighten any special marriage, special courts under Special Marriage Act is constituted in Arunachal?
I have no knowledge. My lord, also the special marriage that regarding the bench, it is not mentioned, my lord.
No, it's a division bench.
In the act, my lord.
Yes. That's why. Then why there will be two? And therefore, earlier there was a notification saying that since Special Marriage Act, it is division bench, therefore all appeals from district judge will be division bench. Prior to this notification, 2nd of May 2024. 2nd of May, prior to this notification, all matrimonial appeals were to be listed before division bench. However, by this notification, a distinction is made because otherwise, the Hindu Marriage Act or other acts says an appeal will lie to a court as if it is a decree passed by a competent civil court. So, in case of a decree passed by a district judge, it will be a single judge.
In the Hindu Marriage Act,
yes,
specifically.
No, not specifically. It says to a court which otherwise which can deal with a decree passed by a district judge.
My lord.
So it will be a single judge. That's why this notification is given. Now, only question here remains is whether there are special courts constituted in Arunachal Pradesh.
My lord, as said, we till now, my lord, there's no such constitution, my lord. Now,
so if there is no constitution, your suit was under Special Marriage Act.
My lord, that,
so all meaning and purport that judge has exercised his power under the Act. When it is done under the Act, a decree is part under the Special Marriage Act, and then the second part, first part will be applicable, not the second part. Huh? Hard. Learned counsel for the petition. It is seen that the present matrimonial appeal, which is registered as RFA, is listed before this court in reference to a notification dated 22nd of May 2024, issued by Registrar General. The said notification is quoted herein below. Full stop. The record reveals that the suit for divorce, huh? Suit
Yes,
for divorce
divorce.
was filed under section
20, clause, subsection B.
which page?
My lord, at page 37, my lord.
Page 37. Under page 37. Under clause B, Swensu. It is stated at the bar that in the state of Arunachal Pradesh, no special court has yet been constituted under the Special Marriage Act to deal with the matters under Special Marriage Act 1954. Full stop. That being the position, the decree which is under challenge in the present case shall mean, if that be so, if that be so, the decree under challenge shall all meaning and purport has been passed under the Special Marriage Act. And therefore, in that event, in terms of the notification dated 2nd of May 2024, the present appeal shall lie before a division bench. Full stop. This court has not expressed concrete opinion in this regard, as this court is not exactly aware whether special courts are constituted and whether the impugned judgment has been passed in exercise of power under the Special Marriage Act 1954. Registry to verify and, if necessary, take clarification from the Registrar General and list this matter after a week. Many matters are being listed like this.
My lord, my lord.
Yes.
Take your time.
No case.
What's it?
Not at this stage. Best option is to wait for the examination of the victims.
No, Lordship, that is already done.
Where is that?
All the witnesses been examined. Lordship.
All the, then why are you? Scan copies are there?
Now, next date he speaks for 313, Lordship. On 4th of the November, Lordship.
Then why should we grant you bail at this stage?
Lordship, when I filed before the trial court, special.
We understand.
Yeah.
See, you just remind yourself, and we will also remind ourselves, this is the bail after search. It is not in the similar footing as that of during investigation. Please show us the statement of the victim. I have not gone to find anything, but only I have gone through her statement under 161 and 164. You are the relative. Is he?
Yes,
Who is this petitioner?
petitioner is lots of pillar sister of this case.
No, the accused.
Accused is
Brother-in-law.
no, not yes, brother-in-law.
Brother-in-law of the victim.
Yes.
Some uncle or something. She was here, their husband of her, she She went to school, office and all. This girl was staying there for study and all, is not it?
Lots of the allegation will be something else, but that the trial court will pass the judgment later. But before that, lots of things is that if this honorable court grant the bail, lots of I can be defense my case very clearly, lots of, because of custody, I cannot properly defend my case.
Show us the statement. Yes, Argo.
Yeah, Lordship, in this case, Lordship, FIR is there, Lordship, on the 23rd June 2020.
I've seen that, everything I've seen, you argue on that.
Nothing is there, Lordship. I have the.
There is no contradiction. Please do not invite anything which will damage your case. This is not the way to file a bail at this stage. You are inviting comments from us. Even you have not denied the incident, only if you wanted to create a doubt that she was not given medicine and all those and for abortive and all. Nothing is there.
Lordship, in that case, I will withdraw.
Withdraw.
Fine, press.
The learned counsel for the petitioner submits that as the matter is, the trial is almost over and it is fixed for examination of the witness under section 313 CRPC. He would not like to press the present bail application at this stage. Accordingly, the bail application sent closed. And they record others, Nikita and all, because she is representing legal aid as a legal aid counsel.
No, no.
No, okay, respond number two.
Responded to.
Respond. Why are you before this court? What is your name? This MS Aysang Umse is the petitioner, not the accused. Okay. Scan copy has not come. That will be required. It is seen that you are appearing.
Yes, madam.
Okay. Though the service is complete, the scanned copy of the case record has not yet been received from the district judge, from the court of Learned District and Session Judge Teju, registry to issue reminder and list this matter on Monday will come.
5th or 7th.
Teju, Monday it will come. It comes. It will be scanned copy, of course.
Yes,
Okay.
7th November.
7th.
jail, madam. 7
Ah.
5th then.
5th of
5th.
Yes.
Hearing of IAM.
Yes, who is for the other side? Name shown.
As per the order dated 10 May 2024 by this honorable court, the court, this honorable court has directed the opponent to take press statement. As per that notified on 15 May 2024, the petitioner had published a
No, 9/8/2024 says Wakalatnama filed by the Learned Counsel on behalf of the sole respondent. And the same is placed in record, is not it? Now, this is item number 8. No name is shown. Is not it? So without saying, I was otherwise inclined to condone this delay. Only how many days? For how many days? 4 days. Who is the counsel? Huh? Where is he? Call him. Is he here?
Lordship, due to unavoidable medical condition, he is out of the station.
Heard the Learned Counsel for the petitioner. This is an application. Filed. Civil revision petition is under what provision of law? 227 or something different? Give the main case. You people are not at all ready with your matters. These are the vital questions. 227. The present application under present application is filed under section 5 of the Limitation Act 1963 for condonation of delay of 4 days in preferring the connected civil revision petition under Article 227 of the Constitution of India. Full stop. In the considered opinion of this court, there is no prescription under Limitation Act prescribing any period for preferring an application under Article 227 of the Constitution of India, inasmuch as such power is a supervisory power of this court. However, it needless to say that this court may not entertain an application under Section 227 of India when the petition is hit by unreasonable delay and laches on the part of the petitioner, and not for any prescription under Limitation Act. Be that as it may, considering the above, it is provided that the petitioner cannot be said to be the petition cannot be said to be unreasonably delayed, and therefore this court is of the view that the connected application filed under Section 5 is not necessary to be filed in the present case. Accordingly, IS stands closed. Civil revision petition is be listed in the motion column.
Due to non-evidence of the process, so right of the petitioner not to be due to medical condition, non-evidence of the physical condition, so the right of interest of petitioner not to be
You are for the petitioner. So we have said that no delays, it is within prescribed. So it is, let this matter be listed in the motion column, reflecting the name of the learned counsel for the respondent. Where is the prescription of Limitation Act? Can you show me the schedule where it is said that 227 is included? 226 and 227, these are separate powers. Yes. Yes, what is this? What is it?
Crossing petition.
On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after 3 weeks. We will not compromise compromise with arms and all. Okay, sir. Next time I will pass a judgment incorporating all those things. This putting people under threat, beating, using arms, these cannot be compromised. I lay specific law for Arunachal Pradesh. Yes. Okay.
Milord, on the last day of hearing, LCR was called for. LCR also already submitted. So kindly fix the matter for admission here.
This matter is ready as regards service and record. Accordingly, list this matter for admission
Here.
in the admission column on.
After list after 4 weeks.
Why 4 weeks?
So
After 3.
2 weeks after.
After 3 weeks.
Why 2 weeks? This is ready. We will hear next week.
Milord, after 3 weeks. Milord.
Any stay operating?
Yes.
Oh, that's right. List this matter on. Give a date.
List after 3 weeks. Milord.
Not 2 weeks. Give a specific date. Yes. Give a specific date.
18 December, Milord.
18th of December 2024. Maybe 2 weeks, 3 weeks, but date. Interim order pass only shall continue till then. Right.
Number 11.
Service is complete.
Lordship. A record is
This matter is ready as regards service. List this matter in the admission column when
after 3 weeks.
after 3 hours. Any interim order?
Yeah, Lord.
Yes, give a date. 18th of November. Yes.
Yes, Your Lordship.
Interim order pass or shall continue till then.
Yes.
Yes.
Oblige, Your Lordship.
Item number 14.
Appeal stands allowed.
Oblige.
But you may not get the copy today, maybe tomorrow.
Yes. Oblige, Your Lordship.
Huh? Appeal disposal, IA disposal, everything is disposal. Item 14, there are one appeal and one IA. Both are disposal.
Item number 15.
Okay, just call item number 2.
Item number 2.
Just wait for a minute, Mr. Mujumdar. What to do? Today is the last day. Let me not dismiss in that way.
Well,
You have a good
last
case. Only thing what will happen, will remand it.
it will remain, it
We
will
will
be.
remand it to the court.
No, no,
Since not keeping well and all.
no.
Next
Next week,
prayer
I'll-
of the learned counsel for the petitioner, matter stands adjourned and be listed on.
No,
When,
fifth,
when?
five, Your Honor, 5
Huh?
November.
Fifth,
Fifth.
fifth of November.
All right.
Very
Oblige.
limited scope.
No.
If that be so, it will be remanded. That's all.
Lordship, interim may be continued.
Interim
Till then.
order, parcel shall continue till then.
Oblige.
Item number 15.
This is the last item. Huh? Okay. So for my Diwali food.
My. Might be, Your Lordship.
Yes.
May I please, madam?
Yes.
Uh,
Let him start because he has filed the IA.
Yeah.
Are you ready?
Yeah, ready.
So since he has filed the IA, we are not going to the main issue. I think you have understood, he has raised filed an application saying that your election petition should not be proceeded further and should be dismissed for violation of such provision, some provision of law.
Yeah.
So therefore, this we are hearing today, not the main case, but IA criminal, sorry, IAC 188, is that it?
My lord, yes, my lord, he's I believe he's a lawyer, so he understands what.
He's a lawyer.
My,
Okay, then.
No, I am not a lawyer. I am in person.
Huh?
I am in person.
No, you are in person, but by profession you are a lawyer.
No, no, by profession I am not lawyer.
Okay.
I am
Okay.
social service. I am a social worker.
Okay. So let him start.
but he has a law degree, I believe.
No, that doesn't matter here, na.
No. I'm just saying, I'm told I have no personal knowledge. Here you are in person.
Yeah.
In person. Okay, so let him argue, then you will reply.
Since I am the applicant.
Since
in the
he is
IA,
the applicant,
Yeah.
in the election petition, you will have a right to start.
Yeah.
Okay,
Oh.
as per the procedure. Now, since this is an application filed by him, now he will start. What is his objection? Then you will reply. Then I will make it CAV because I am not going to dictate anything today. Already criminal appeal one is silent.
My lord. My lord, this is an election petition challenging my election to 53 Changlang North ST constituency. In fact, Legislative Assembly constituency. And I was declared elected on 22nd of June 2024. And in fact, my lord, I polled around 4,524 votes. And the election petitioner has polled only 75 votes. This data has got some relevance, my lord. I'll rely on one judgment.
Okay, this is basically challenge Sanglang, is that it?
Changlang North ST
Sanglang
constituency.
North ST, any number?
53, my lord.
53. Okay,
My lord, the prayer made in the election petition is, I'm not taking through various pages, my lord. I'll just submit. Prayer made in the election petition is that the nomination paper submitted by the respondent number 1 returned candidate whom I am representing, my lord, is void. Number two, election of respondent number one to be declared as void as he has been elected after filing nomination paper by corrupt practice. This is the prayer mail. And thirdly, any other order under section 98, 99, 100, 101. It also is aware that there is various provisions under which the Honorable Court has been conferred with the power of passing various types of directions, apart from directing that the election of the return candidate is void. So that is why all the prayers are there. Now, in the election petition, as I have gone through, my lord, I find that the election of the
You can
return
you can sit.
election of the return candidate has been challenged primarily on the ground that the nomination paper has been improperly accepted. Lots is aware there is a provision in the section 100 of the Act, RP Act, that if there is an improper acceptance, then the election can be declared to be void, provided he shows, he has got a further burden of showing that it has materially affected the election of the return candidate. But the ground is improper. The ground for saying that it is improperly accepted is that the Form 26 appended to the nomination paper, which has to contain various information about the candidate, is defective on the ground that
Just a minute, just a minute. I think I can ask her to.
yes, I'll take at least 1.5 hours minimum. Wait.
Yes.
My lord, the ground on which the Form 26 of the nomination paper is said to be defective is that all the information relating to the return candidate have not been disclosed in the nomination paper in the Form 26. That is the ground, my lord. Rule 4A. My lord, Rule 4A of the conduct of election rules. I'm just referring to Rule 4A once. I'll
Yes,
be
books,
going
books, books.
to
RPX.
RPX, representation of people.
Representation of people.
For the time being, what you can use this A to detail. Ase? Possibly if that is the new book, page 195, that you make straight way turn
195.
195.
Just a minute.
Form 4, Rule 4A, my lord.
Rule 4A of election conduct rules.
Conduct rules, my lord. Conduct of election rules.
1961.
My lord.
1961 rule.
My lord.
Just a minute. Rule 4.
4A. 4A, my lord.
Rule
Capital
4, 1, 2, 3, Rule 4. Nomination paper. Is that
My
it?
lord. My lord.
Rule 4A.
4A. This is
Yes.
affidavit, my lord. Affidavit to be appended with the nomination paper.
186. Page is 186.
I'm sorry, this is a different page. Well, Rule 4A, your lordship will find form of affidavit to be filed at the time of delivering nomination paper. The candidate or his proposer, as the case may be, shall at the time of delivering to the returning officer the nomination paper under subsection 1 of section 33 of the Act, also deliver to him an affidavit sworn by the candidate before a magistrate of the first class or a notary in Form 26. So apart from this nomination paper, my lord, which is required to be submitted in terms of section 33 and now also under section 33A, my lord has to submit a form filled in under Rule 4A of the Conduct of Election Rules. Now, in this case, my lord, I will be referring to these provisions at a later point of time. Now, I'll straightway turn to the election petition because, my lord, I have filed the application basically under Order 7, Rule 11, saying that the contents of the election petition do not disclose the cause of action to challenge the election of the returned candidate. No cause of action. Rejection of the election petition. Well, I did not go to my petition because Supreme Court in one judgment has made it very clear that while dealing with an application under Order 7, Rule 11, the contents of Order 7, Rule 11 petition is irrelevant. It is only the petition, election petition, along with the documents. This is the foundation. So my, exactly, man. Petition. So my petition, what I have said in my petition is not material. Apart from the fact, only the fact that I have said that it doesn't contain the material facts necessary to constitute a cause of action. Any other thing, if I have stated there on merit, will have no relevance. Now, the defect, the election, the defect which the election petition has mentioned, your lordship will find from paragraph 8 onwards, my lord. At page 9. Page 9, my lord, paragraph 8. 9, para 8. Well, paragraph 8 is only, since the allegations are summarized in paragraph 8, that is why I'm saying. Otherwise, the facts are given from paragraph 9. I'm drawing your lordship's attention to para 8 of the election petition. Page 9. That even though the respondent 1 succeeded in securing highest number of votes and elected from 53 Changlang North ST Legislative Assembly constituency in the state of Arunachal Pradesh, some apparent irregularities were found during filing of his nomination paper before the returning officer, and the returning officer deliberately ignored the issue, notwithstanding knowing the fact or for the reason best known to them. It is further stated by the petitioner that in spite of having clear rules as well as notification in respect of filing nomination paper after complying all the requisite forms, without failure, the respondent 1 did not submit his nomination paper with clear hand. Well, bare facts are not there, it is only a summary. From paragraph 9 contains all the allegations. I may just submit the allegations made in the election petition, in particular paragraph 9, are primarily correct. The only submission I'll be making is, my lord, and I'll try to impress upon your lordship, is that the facts which are stated here are not sufficient to hold that the nomination paper is invalid, because these are certain facts which do not go to the root of the matter, and in a recent judgment, And unfortunately, it was from here, and I argued it here, and it went there. There, the Honorable Supreme Court has made it very clear that every small fact need not be given in the affidavit. Unless there is a substantial defect. Well, section 36, I'll go to take a lordship to section 36 of the Act also, which says that unless the defect is of substantive nature, there is no question of holding that it is invalid. So now, my lord, bare facts at para 9 at page 10. These are the basic allegations. That subsequently, after respondent number 1 has been elected from so-and-so, it has come to the knowledge of the public that respondent number 1, being an intending candidate from the said Legislative Assembly constituency, deliberately submitted his nomination paper with clear violation of law and procedure, which are as follows. A. Affidavit for serial number 101-2024, 2 sets. Well, there were altogether, I think, 3 sets of nomination paper. This is A, 1 set. There are 2 sets numbering affidavit for serial number 101-24. Affidavit was sworn before an executive magistrate by affixing judicial court fee on every sheet of paper. Later on, it was found that first pages of the said 2 sheets of affidavits were replaced by non-judicial stamp paper of ₹100. The executive magistrate has no power to sworn any affidavit. Chapter 3, in respect of nomination and allotment of symbols, it is clearly stated that the affidavit should be sworn before a first-class magistrate or a notary public or a commissioner of oath appointed by the High Court of the state concerned. The changing of first page of affidavits with stamp papers is a clear indication that respondent number 1 was informed by the returning officer to remove the defect, but in spite of that, respondent number 1 did not swear the affidavit before the proper authority as mentioned above, which is also clearly reflected at note 2 of the last page of the affidavit. Well, I'll refer to this note 2. This is there in the book at appropriate stage. Similarly, it is apparent that many columns are kept blank, and in some columns no information has been furnished as directed, sought in the affidavit. It is clearly stated or reflected in note 3 of the affidavit that all columns should be filled up and no column should be left blank. If there is no information to furnish in respect of any item, either nil or not applicable as the case may be, should be mentioned. Now B, para 6, no tick mark has been shown as sought. Now para 6C, para 6A, no information provided as directed. A handwritten NA is allegedly seen which might be filled up afterwards to fill up the gap by someone which is objectionable and improper. D, motor vehicle, etc. No information has been provided in connection with make and year of purchase of vehicle shown. The information has not been supplied in case of self as well as of spouse. Jewelry, etc. No information has been provided in connection with weight of the jewelry. No separate value has been shown. Next, F, movable assets. No information has been provided as sought at gross total value of movable assets. All columns are kept blank, which is against the directive of the Supreme Court of India and also as per note 3 of last page of the affidavit. Agricultural land. Land is not shown in acres as per the form of or directed sought. No date of purchase is reflected. No cost of land as because the land has been shown as not inherited. H, no non-agricultural land of spouse. No cost of land purchase has been provided as the date of purchase has been shown as 4/8/2010. Then dues to department, etc. The second column is blank. J, income tax column, the second column is blank. Part B, pending case shown is nil, but in the affidavit file wide serial number 210/2024 affidavit file, an appeal is shown pending as per the information provided. Lastly, part B, approximate current market value. In this column of part B, the first 2 columns is kept blank. Then highest educational qualification, this column is totally kept blank. These are the allegations. Now the third set of affidavit, serial number 210/2024, I find the allegations are absolutely same. So I need not go. Now Same. Now I'll take your lordship one by one what has happened, madam. So far as page, I am drawing your lordship attention to para 9, page 10 again, madam. The first allegation is A, affidavit for serial number 101 in 2 sets. The affidavit was shown before an executive magistrate and my lord, and some replacement of first pages, but then replacement was before the scrutiny. That is also very clear. Now I'll show your lordship. Lordship may kindly take my IA first. Affidavit to check part of the whole very absolutely. Affidavit to part of the whole form. Not yes. My lord, may kindly see page 33 of my IA. It was IA. Oh, yes. Yes. Scrutiny to get here. 20? 28. And scrutiny of the nomination paper was held on 28th of March. Lord, you may kindly take the date, my lord. That is available at page 6 of the election petition also. On 28th of March 2024. Page, page 6 of the election petition. Now, Lordship may turn to page 33 of my IA. There I have annexed a document issued by the Joint Chief Electoral Officer, Arunachal Pradesh, Itanagar. If your Lordship has got that document. This is addressed to all district election officers, returning officers, assistant returning officers of Arunachal Pradesh. Exercise of judicial magistrate power by the executive officers, namely ADC, SDO, EAC, etc., in administering swearing of affidavit for filing nomination regarding. Sir, I am directed to forward here with Commission's letter, that is Election Commission's letter, dated 22nd of March. 22nd of March, 2024, madam. 22nd of March 2024 on the subject mentioned above. 33, my lord. Yes, on the subject mentioned above for your information necessary action. Commission's approval may be brought to the notice of all concerned, including political parties in your jurisdiction in writing for compliance. Now, next page, you also will find that letter of the Election Commission of India. Next page says, subject exercise of judicial magistrate power by I'm sorry, then Lordship may kindly turn to page 33. Yes. My lord, 33 is the my lord. Yes, ma'am. So 30 here it is 33 and 34 somehow. My lord, ma'am. So 33 in your lordship petition will find. This is a letter from the Election Commission of India to the Chief Electoral Officer. Subject is exercise of judicial magistrate power by the executive officers, namely ADC, SDO, EAC, etc., in administering wearing of affidavit for filing nomination regarding. With reference to your letter number so-and-so on the above subject, I am directed to say that in view of the position explained therein and notification number so-and-so dated 26th of July 2023 of the Law, Legislative and Justice Department, Government of Arunachal Pradesh, the Commission has no objection to allow the executive officers to administer the swearing of affidavits as notary public as a special case. So this point possibly will take, this document will take care of this allegation. Then next page at page 11, the petition says, the changing of first page, Next page, my lord, page 11. The change, yes, changing of allegation is not about changing, my lord. The changing of first page of affidavits with stamp papers is a clear indication that he was informed by the returning officer to remove the defect, but in spite of that, respondent number 1 did not swear the affidavit before the proper authority. So you were aware, but you did not remove this. According to the petitioner, this is a defect. Similarly, it is apparent that many columns are kept blank, and in some columns no information has been furnished as directed or sought in the affidavit. It is clearly stated or reflected in note 3. My lord, for this your lordship will kindly see in the book. My lord, I am coming to that one. 3-1. Page 312 in my book, my lord. 312. Now this your lordship will find Form 26 is there in the conduct of election rules. Lord will find it here in this Form 26. Form 26. Well, after that, my yes. Next page to slow. My lord will find there are some notes. The page machine koi thuise to direct kiba koi loi is. Wait. My lord, that your lordship will find after the after the verification of that form. Last page. My lord. Black or note. My lord. Yes. My lord, in the election petition, there is a mention of note 2 at page 11. At page 11 of the election petition, there is a mention of note 2, note 3. So this your lordship will find note 3 till now, my lord. That your lordship. And the third, note number 3 also, it has been mentioned here. It says all columns should be filled up and no column to be left blank. If there is no information to furnish in respect of any item, either nil or not applicable, as the case may be, should be mentioned. And lastly, the affidavit should be either typed or written legibly and neatly. So handwriting is also permissible. So here, my lord, page 11 again, I am turning to my lord. Page 11, if your lordship finds, my lord, the second paragraph says, similarly, it is apparent that many columns are kept blanks, which according to the note 3, my lord, should not be there. And then it says note 3 of the affidavit that this quotation is from this part of the book, my lord. Then B, para 6, no tick mark has been shown as sought. So far as the middle paragraph is concerned, my lord, although it has been mentioned, but then specifically no specific part of the Form 26 affidavit is referred here. That is why I cannot take your lordship to that. But so far as the allegation in B is concerned, small b, para 6, no tick mark has been shown as sought. Lordship has to turn to page 91 of the election petition. 91. Yes, this is B. Page 91, man. Para 6. My lord, there are more than one affidavit. Lordship, I am supplying the information. Annexure F at page 72 is the affidavit of 2019, Form 26. Lordship may kindly take a note, my lord. Yes, present Form 26, there are 3. So all they have annexed. So for that matter, Lordship will see that for page 88 is the first Form 26. 88. 88. Yes. Second, your Lordship may mark page 117 is the second affidavit. 117. Allegations, my lord. Yes. Third one is at page, my lord, 146. My lord. Now, my lord, the allegation at one by one. So allegation at para 11 in small b, my lord, that no tick mark has been shown as sought is a allegation in respect of, Lordship may kindly see at page 91, in respect of the cases of conviction, page 91. In the middle, my lord, serial number 6, cases of conviction. So there are 2 things. One is Roman 1, I declare that I have not been convicted for any criminal offense. Tick this alternative if the candidate has not been convicted, and write not applicable against alternative Roman 2 below. Or 2, I have been convicted for the offenses mentioned below, or the candidate has been convicted, then tick this alternative and score of the alternative 1 above and give details in the table below. If he is convicted, under which section, which court, etc., I have to indicate. So I have not given any tick mark here. This is the allegation number 1. First is allegation with regard to affidavit, my lord. Second is this one. I have this one. So against this allegation, my lord, our response is, Lordship will kindly find in the table when there is I have been asked to give name of the code, sections under which I have been convicted. I say not applicable. Yes. Yes. My lord, that is my submission. Absolutely. That is my submission. So far as this allegation is concerned, my submission is when I have
The objects of
my lord,
whether I am convicted or not is
declared my, that is my reply. Now next is my lord, para 6A at page 11. This is under small c. No information provided as directed. A handwritten NA is allegedly seen, which might be filled up afterwards to fill the gap by someone which is objectionable and improper. My lord, that your lordship will find at page 92. 6A says, my lord, I have given full and up-to-date information to my political party about all pending criminal cases against me and about all cases of conviction as given in paragraph so and so and so and so, not applicable. So I have shown from the note that handwriting is also permissible in the Form 26. So by way of handwriting, I have informed that it is not applicable. Then comes page 12, small d, my lord. Page 12, small d. This is regarding motor vehicle. Page 100, your lordship will find this. This needs some exercise, my lord, to find out where that allegation is. And unless I find that, if I search at this stage, it will be difficult for your lordship to appreciate. Page 100, your lordship will find Roman 6. Motor vehicles, I have in the form requires that motor vehicles, aircraft, yachts, ships, Details of make, registration number, etc., year of purchase and amount. Now your lordship will find the information I have given. Tata TC truck, number so and so. Then, yes, Mahindra Scorpio, number, registration number, price, everything I have given. Only they say in respect of second column is for spouse. For spouse also I have given Mahindra Bolero, then Creta car, etc. Number, price I have mentioned. Now, since it says the details of make, registration number, year of purchase and amount. Amount I have given, year of purchase I have not given, and other things are there. Now, whether this will amount to a substantial defect. This your lordship will kindly take note, and I'll argue with the support of the judgment that this will not be a substantial defect. If I don't disclose the vehicle itself, my lord, then matter would be different. Even then, my lord, the Supreme Court in my case say that if there are 10 vehicles and if someone has not mentioned one vehicle, that will not amount to substantial defect. So this is with regard to vehicle. Next comes jewelry, my lord, page 12. That your lordship will find at page 101. Jewelry. 101. Jewelry, your lordship will find at page 101. Jewelry, bullion, and valuable things. No, weight. No separate value has been showed and weight. Now, jewelry, page 101, my lord. Jewelry, bullion, and valuable things give details of weight and value. So, what I have given, clear 90. What I have given is, my lord, jewelry, ring, 4 numbers, chain, 1 number, bracelet, 1 number, and value I have given 2,40,000. Bullion, nil. 3 numbers of guns. 3 guns, nil. 12 bore SBBL gun, valued at rupees 2 lakh. Then 380 NPB, valued at rupees 2,50,000. Then 30 NPB carbine rifle, valued at rupees 2 lakh. Under so and so number and so and so. Yes. That's all, man. So, man, here only the weight is not there. Lordship may kindly take note when the weight is not there. Year of purchase not given. Then next comes F at page 22. Movable assets that you lordship will find at page 103. There are in fact, my lord, although it is not very clearly mentioned, the allegation is no information has been provided as sought as gross total value of movable assets. So the assets which I have just now referred to, my lord, in respect of which there are allegations of no year of purchase, etc. There, at the end of the column, it says gross total value I have to give. That gross total value I have not added and given. That is the allegation. Page 103, my lord. I'm 102. On top, you will also find gross total value left inside. This refers to the gross total. No, just above that, my lord, left hand side. Gross total value. Lordship is seen. Just gross total value. Yes, my lord. Jewelry, etc. Vehicle, etc. That is, they have mentioned here. My lord. Yes. Now, page 12, small f says, no information has been provided as sought at gross total value of movable assets. That means about this jewelry, etc. This is the allegation. Second is, my lord, all columns are kept blank, which is against the directive of the Supreme Court of India and also for note 3 of the last page of the affidavit. So this is again, my lord, information about the book, no allegation as such. But the second part of small f at page 12. All columns are kept blank which is against the directive of the Supreme Court of India and also as per note 3 of the second sentence, all columns. Yes. Well, this is in respect of what is not very clear. So I go to the next para. There is G, agricultural land. And they have not mentioned. That is why I am saying, my lord, I mention. So, my lord, next is G, small g at page 12, agricultural land. That your lordship will find at page 103. Allegation is land is not shown in acres as per the form of or directed or sought. No date of purchase is reflected, no cost of land as because the land has been shown as not inherited. Now that your lordship will find at page 103. Detail of balance under capital B, detail of movable assets. 1, 2, 3, then thereafter agricultural land. I have given. Yes, my lord. So for self, I have given agricultural land, all the information I have supplied in the next page, my lord. We have given it in Bigha. Now, if it is in Bigha, my lord, all that the requirement is that I should indicate the area measurement of the land. Acre. Oh, yes. কিতাপত আছে নেকি? I'll just find it. That your lordship will find in the book, my lord, under form 26, capital B, details of immovable assets. There it is mentioned, my lord. Page, my lord, my lord, it will be under form 26. After move, it will be serial number capital B, my lord. Capital B. Yes. 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 Under that, lordship will find agricultural land, location, survey number, then area, total measurement in. My lord, important, my lord. Different book. Yes. Details of movable, note 1, etc. Note 1, 2, 3, we can just keep, my lord. Then in the column, first column is description. Agricultural land, location, survey number. Then next is area, total measurement in acre. This is the allegation. In some areas, it is shown in acre. In some area, it is in. But in bighas, I have given the measurement. I have given, but in bigha. Locally, it is normally used in bigha. Location, survey number, and next is yes. But then measurement I have given in bigha. Madam. Purchase. Madam. Given. Page 104. man. Yes. 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 Then page 105, 4 lots will find. Yes. This is in respect of next allegation about non-agricultural. Okay? Yes, non-agricultural. Page 12 again I am coming, madam, about the allegation. Page 12, bottom paragraph, small h, non-agricultural land of spouse. No cost of land purchase has been provided as the date of purchase has been shown as H. Page 12 and relevant page 104, man. So here I have given about the non-agricultural land, everything, every information about spouse. So far as self is concerned, it is nil. Date of purchase I have given at the bottom, minor, because it is not inherited. 4, man. Yeah. My lord, second column is for spouse, rest are for dependent. That your lord will find at page 103. 102, I'm sorry. 102, man. Yes, man. Yes. Page 104, man. So date of purchase is given. Cost of land in case of purchase at the time of purchase. Allegation is no cost of land purchase has been provided as per the date of purchase has been shown as 4/8/2010. But so far as cost of land in case of purchase at the time of purchase, we have said not. Yes, ma'am. Yes, and date of allotment is given. But next page, at page 105, we have given the value of also. Next page, 105. Yes, this is in respect of a possibly building. Yes. Building. There is no allegation about this one. Next page, at page 13 of the petition, my lord. Dues to department, etc. That you'll also find at page 108. I have mentioned nil, not applicable. I have given the answer. Page 108. 8. Second one, yes. Yes. Second column is they say blank. I don't know how second column is. Second column is spouse. It is given. Filled up. Since there is a gap in between, possibly it was thought that there is another column. Possibly, I don't know. Between the self and the spouse, there is a gap in the printed form. Possibly the impression was that there might be. And then income tax column, second column blank. page 109, I think.
109.
Income tax. Yes.
Income tax rate. One.
Page 110, madam. 0. Madam.
Yeah.
Yes.
People plan.
Form 2 kita apa? Form 2 can go association. 888. Madam, form your lordship will find. Department income tax. Income tax. Income tax এটাই করা আছে form. Yes. We have said nil, madam. Nil, page 110. Yes. Page 110. Roman 4. Yes. Nil. Nil as a whole. Yes. Not against. Yes. Regarding dues to department, I have to indicate one more thing. 108 and page 109 may have some relevance, madam. 109. It 109, if your lordships you find on the left hand side, government dues to depart occupy, yes. So we have, has the department been in occupation, has the deponent being in occupation of the accommodation provided by the government? We have said yes, because he was an MLA. And down below, note, no due certificate from the agencies concerned in respect of rent, electricity charges, water charges, and telephone charges for the above government accommodation should be submitted. That we have submitted, so there is no allegation therefore. And then 110, your lordship has already taken note of. Then comes the allegation of part B at page 112, my lord, regarding criminal case. 112. Yes. Page 113, my lord, there is a, down below there is part B. Page 112. Yes. The down below there is a part B, and under that serial number 5. Total number of pending criminal cases, we have said nil. Total number of cases in which convicted, we have said nil. Yes. And then, my lord, there is one more allegation about I'm coming to that. I'll clarify that also. After that, lordship, may kindly see approximate current market value. It will part B. The first two column is kept billing. Part B. Market value. You want to yes, yes. Assets and liabilities. It is all information given. Yes, second page, page 114. Approximate current market price. 114. Approximate current market price here it is blank. Yes. And then last, kota se tu, if inherited, kota se. My lord, it is mentioned if inherited, Lord, will kindly note. Page 114 on the left hand side. Approximate current market price, self-acquired assets, total value B. Yes. Inherited assets, total value. So, manual. Total, yes. Immovable total also given. Yes, yes, yes. And at page 112, one more information will be necessary, my lord, regarding education qualification. Because at page 13, it. Yes. My educational qualification at page 112, I mentioned past Bachelor of Arts from Rangfra Government College, Changlang, Arunachal Pradesh. Mentioned. The allegation is this column is totally kept blank in part B. Part B at page 112 possibly. Part B 115. 115 minutes. 15 minutes. Nothing is mentioned. Now, and keep page 149. Now, page 149 will have some relevance. My lord. Regarding the criminal case, my lord. In the second affidavit, starting from page 146. Page 146 in the table, my lord, G. 149 or yes. Because at page 13, the allegation is pending case shown is nil, but in the affidavit filed by serial number 210, affidavit file, an appeal is shown pending as per information provided. This is the allegation at page 13. Now, in the reply, I'm saying page 149, whether any appeal or application for revision has been filed against the proceedings mentioned, yes. Criminal petition number so-and-so arising out of IA criminal case number so-and-so, filed under section 156(3) CRPC by Sri so-and-so against the respondent, my lord, before Honorable Special Judge is so-and-so. This is the case, my lord. It will order, no? Do you photo? Well, the order also, your lordship can take judicial notice of this. 156(3) itself says that somebody wants that case to be registered against me. Yeah, they're into the June. Yes. And this is the position. These are the additions. Same. Now, lordship will kindly see what are his other allegations. Page. Page, I'll take the lordship to para 10 at page 16 now to refer to other allegations made. Para 16 at page 10. The contents made para 8 of this petition are the contents of written objection raised by the election petitioner during scrutiny, as because the election petitioner apprehended that the returning officer shall favor Sri Swans, there is a return candidate, who has happened to be the incumbent deputy speaker of Arunachal Pradesh Legislative Assembly. The election petitioner's apprehension that the returning officer shall favor Sri Tesam Pongte has another reason. The reason is that sitting MP, a contesting candidate of BJP from East Parliamentary Constituency of Arunachal Pradesh for the general election 2024, which was held on so Sri Tabir Gao clearly and specifically warned the responsible officials of government of Arunachal Pradesh to support the contesting candidate of BJP, else they shall face consequences. The threatening was given in an election campaign meeting, which is available in social media and was broadcast in Arun Bhumi news channel. He has clearly stated that it was direction from the Chief Minister of Arunachal Pradesh. Lordship is rising. I'll refer to this. Man. In para 16 and 17, the allegation para 10 is that one Tapir Galo, page 16, man. Yes, para 10. Yes. It continues up to page 17, my lord. Here the allegation is that in Arun Bhumi news channel, some news came and that one Mr. Tapir Galo, who is possibly the MP, has requested all government officials to support the BJP candidate. This is the allegation. This is the allegation of power practice, man. Possibly the allegation of power practice of undue influence, although it's not mentioned. Then next paragraph, para 11. The result of entire election so far as the election of by MP. No. That the result of entire election so far as the election petition, election of respondent 1 from so-and-so constituency is concerned, is vitiated because of violation of section 100B of the Representation People Act. Then next parameter. Respondent number 1, along with his election agent and supporters, committed corrupt practice on the day of submission of nomination paper, as they did not file affidavit on the day of filing nomination paper. If the respondent number 1, along with his election agent, was prevented from filing an invalid nomination, then surely a genuine candidate would have won the election by a good margin of votes. I do not know what is the exact allegation in this case, in this paragraph. First part says that respondent number 1, along with his election agent and supporters, committed corrupt practice on the day of submission of nomination paper, as they did not file affidavit. So for not filing affidavit on the day of filing of nomination paper, this is slightly vague manner. And second part says that had he been prevented, a genuine candidate would have submitted his nomination paper. This yes. Yes. My land friend will
May I interrupt, my lord? The nomination was filed on that day, but affidavit was not submitted. That is the ground.
All right. Then I get the point, man. Although it is not very clearly mentioned, I will reply to that. Para 13. The respondent number 1 and his election agent has committed the corrupt practice of deliberately filing an invalid and complete nomination paper. As such, all the votes cast by voters in the favor of respondent number 1 are invalid, and it has become evident that votes secured by him in the aforesaid manner of commission of corrupt practice. All these votes are invalid and the same are liable to be rejected, which were purportedly secured by respondent number 1. Hence, it is prayed that genuine and lawful candidates entitled to be declared to be elected from the constituency concerned. Para 14 is important, my lord. That for the purpose of filing the present election petition, the petitioner submitted written objection dated 28/3/2024 at the time of scrutiny before the returning officer of so-and-so constituency with a request to reject the nomination paper. So he has filed the objection basically for the purpose of filing an election petition. Then para 15, that in spite of verbal objection raised during scrutiny and the receipt of the aforesaid application, written objection submitted by the returning officer, neither any seen to be taken against the respondent number one for prior practice for the reason that best known to the returning officer or the authority concerned. Then it is worth to mention that in the previous election also respondent number one did similar prior practice, and hence it can be safely said that respondent number one intentionally and with clear disregard to the Constitution of India, election rules and guidelines, and most particularly guidelines of the Honorable Supreme Court in WPC and so and so, file incomplete nomination paper. In fact, he never filed a proper nomination paper as per guidelines of the Honorable Supreme Court. In the official website of Election Commission of India, it is stated by the petitioner that same serial number being 101/2024 dated 26/3/2024, and the time of swearing has been shown as 12:30 p.m. in two different sets of affidavits, and the serial number of non-judicial stamp paper for both the affidavits are same, that is A124552. It is further stated that the serial number of third set of affidavit is 210/2024 dated so and so. Next paragraph, that the result of election insofar as it concerns the respondent number one is materially affected due to commission of prior practice within the meaning of deliberately filing invalid nomination paper under section so and so, and under such circumstances having left with no other option, the petitioner is preferring the present petition, praying for equitable relief which may be allowed by the Honorable Court. That apart from the question of commission of prior practice of filing a nomination paper by respondent one in a wrong way with the help of district administration, who were apparently prevented to take action against respondent number one, even after witnessing an irregularity in filing the erroneous nomination papers. Accordingly, an eligible candidate would have been declared as elected in so and so constituency seat out of a legitimate and clean nomination in the said election by obtaining valid votes. Therefore, even on this count, independent of the allegation and independent of the allegation of prior, the result of election insofar as it concerns the respondent number one, the returned candidate has been materially affected by improper reception of void nomination by respondent number one within the meaning and provision of section 101D of the RP Act. And as such, the Honorable Court may be pleased to declare the respondent number one to be void with the further declaration that lawful and genuine candidate has been duly elected. And then the rest are valid.
Yes.
My lord, I'm thinking I'll deal with this paragraph 10 allegation first, and then the other allegation in respect of nomination form 26. For this allegation in paragraph 10, my lord, I'll refer to section 83 of the RP Act, my lord, Representation of People Act. Section 83, my lord.
Jail pen read. Yes, section 83.
83.
Yes.
If your lordship may kindly see section 80 first, my lord. 80 says, no election shall be called in question except by an election petition presented in accordance with the provisions of this part. About the content, it is section 83. An election petition shall contain a concise statement of material facts on which the petitioner relies. B. Set forth full particulars of any prior practice that the petitioner alleges, including as full a statement as possible of the names of the parties alleged to have committed such prior practice and the date and place of commission of each such practice, and shall be signed by the petitioner and verified in the manner laid down in the CPC for verification, etc. Then, lordship may kindly see section 100. Man. Section 101 B is important, my lord. A and B. Here I'll be referring to B, but in 101, A is also B. No, A to the B. Six, 101 B, my lord. 101 B. B. Grounds for declaring election to be void. Subject to the provisions of subsection 2 of the High Court is
You are reading 101,
100, my lord. I'm starting 101, my lord.
101.
1.
Grounds for which candidate?
Yes. Subject to the provisions of subsection 2 of the High Court is of the opinion.
It is ground of which the a candidate other than returned candidate may be declared to have been elected.
Under section 100 reads grounds for declaring election to be void.
Okay.
And then subsection 1 says subject to the provisions of subsection 2. If it should be if, my lord, if the High Court is of opinion, of is wrongly printed. I'm strictly going to B because here there is no question of disqualification as under A. That any corrupt practice has been committed by a returned candidate or his election agent or by any other person with the consent of a returned candidate or his election agent, or that there is rest. I mean, I'm skipping for the time being.
Because it's B now.
Yes, my lord, the allegation, if your lordship now goes to para 10, the allegation is one Mr. Tapirgaon, who is the MP, has made an
So you
appeal.
want to say there is no pleading that
Well,
it was done in consent of the
Absolutely.
petitioner
Absolutely.
and no agent specific who has done
Yes,
it, who is
yes.
the name of the agency? Not.
Exactly. My lord, the section 101B says, if the candidate himself has committed corrupt practice, nothing else is required. If the election agent of the returned candidate commits corrupt practice, nothing else is required. But if it is any person other than the returned candidate,
Consent is-
then consent is required. Now, if your lordship goes to para 10 of the election petition, lordship will find there is no allegation that the MP
Against the petitioner,
against the respondent.
specific or respondent,
Yeah.
or against his election agent.
Yes.
Except a statement
Yes.
that there are some people
Appeal,
that stated
appeal in the
this and that,
yes.
and it is published in so
Yes.
Bhumi newspaper that this MP has done.
Yes.
So according to you, it is very essential to plead
Yes.
that so MP has done this corrupted
With my
or
consent.
with the consent. of
My
the-
lord. So in the absence of this allegation, my lord, no cause of action so far as corrupt practice is concerned.
Yes.
In this regard, my lord. And rest of the, my lord, statements made based on this allegation can also be said to be not disclosing any cause of action. Now, and since I read section 83 when it says there you have to give a concise statement of material fact, it is absent. Now I go to the main part, my lord. For that, my lord, as your lordship has seen, my submission will be like this. That this, my lord, law requiring that there should be an affidavit accompanying the nomination paper to disclose all this information. My lord, this law was earlier not there. In your lordship is aware, my lord, in 2000, there was a judgment in this ADR's case, my lord, your lordship is aware, where Delhi High Court for the first time said that, see, there is no law, but then we are directing the Election Commission to compel all the contesting candidates to disclose certain information about them. This was put to challenge before the Honorable Supreme Court. Well, Honorable Supreme Court, your lordship is aware, I am not bringing all the judgments because this will be only prelude to what I will be actually arguing. But then for giving a background of the law, how it has developed, I am saying, my lord, because, my lord, in this judgment rendered by the Supreme Court reported in 2002, 5 SCC 294, these are referred in subsequent judgments which I will be referring to. But this judgment I am not bringing, I am just giving the background, my lord. In this reported case of 2002, 5 SCC 294, para 4578, my lord, and 48, the Honorable
2002 5 SCC.
2002, 5 SCC, page 294. Union of India versus Association for Democratic Reform. It is in short referred as ADR's case.
Yes.
In that case, the Honorable Supreme Court is saying that under Article 19(1)(a), every citizen, it's a little citizen, the voter, has a right, fundamental right to know about the candidate for whom they are voting. Unless they know about the criminal antecedents, unless they know about the candidate, how he is, what asset he has, what liability he has, they are not in a position, they are deprived of their fundamental right to know about the candidate, and that amounts to violation of Article 19(1)(a). And therefore, every candidate must disclose. But since there is no law, there was a direction in that 2002 judgment panel to the Election Commission that you should the candidate should be compelled to disclose. Then, my lord, it went on. Thereafter, the direction was there from the Election Commission. The candidates have been filing, but based on the direction, because there was a direction also to frame a law. There was an ordinance was promulgated, and in the ordinance, my lord, this section 33 of the present RP Act
Was improved.
yes. 33, but then 33 says it is required, but unfortunately, side by side 33B was also said, which says that it is not required. Lordship may just have a look at section 33 once, man. Because today's requirement under Rule 4A is because of these judgments. Lordship may kindly have a look at section 33.
Yes.
33 says 33A, madam, sorry, 33A. Because 33A was inserted by an amendment of 2002 subsequently. Initially, there was an ordinance. 33A says a candidate shall, apart from any information which he is required to furnish under this Act or the rules made thereunder in his nomination paper, delivered under subsection 1 of section 33, also furnish the information as to whether he is accused of any offence punishable with imprisonment for 2 years or more in a pending case in which a charge has been framed by the court of competent jurisdiction. B. Roman 2, he has been convicted of an offence other than an offence referred to in subsection 1 or subsection 2 or covered in subsection 3 of this section 8 and sentenced to imprisonment for 1 year or more. 2. The candidate or his proposer, as the case may be, shall at the time of delivering to the returning officer the nomination paper under subsection 1 of section 33, also deliver to him an affidavit sworn by candidate in a prescribed form verifying the nomination specified in subsection 1. The returning officer shall, as soon as may be, after furnishing of the information to him under subsection 1, display the aforesaid information by affixing a copy of the affidavit delivered under subsection 2 at a conspicuous place at his office for the information of the electors relating to constituency for which the nomination paper is delivered. But interestingly, my lord, section 33B was also there. Candidate to furnish information only under the Act and the rules, notwithstanding anything contained in any judgment. Judgment means that ADR's judgment, my lord. Decree or order.
This was also subsequent to the ADR's judgment.
Yes.
33A and 33B.
My lord. Decree or order of any court or any direction, order or any other instruction issued by the Election Commission, no candidate shall be liable to disclose or furnish any such information in respect of his election, which is not required to be disclosed or furnished under this Act or the rules made thereunder. This was confusing. So this was again put to challenge in the subsequent case, my lord. And after the conclusion, there was an ordinance, my lord. Very interesting. Then the ordinance was again put to challenge. Hearing took place. Hearing was over. Judgment was delivered. Thereafter, the government amended this RP Act, and in this just kept keeping the same language of section 33A and 33B. The Act was amended, and 33A and 33B was brought. So, since there was already a challenge to ordinance, which was the provision of section 33B, the ultimately matter was heard again. The petition was amended, matter was and finally decided, and section 33B was held to be unconstitutional because it violates Article 19(1). And that is reported in my lord 2003 4 SCC, page 399. So from that date, my lord, that 33B is no longer there, 33A is there. Now, in terms of 33A, my lord, Rule 4, conduct of election rules was also amended. And after 4, Rule 4, Rule 4.
Understand why these books are still incorporates this section.
I don't know.
Huh?
To show.
See, this book was, this is an
Printed.
edition of 2022.
Yes. And this was set aside in 2003.
See, this has become redundant.
And in cases, you will find there are some acts where the provision is required to be seen like Land Acquisition Act. Although we have 13, but 1894 we require, but there your lordship will not find those required.
That will not be.
Now, my lord, then after the judgment, this is reported in 2003-4 SSC, this is PUCL versus, my lord, this is called People's Union for Civil Liberties case. Then after this judgment, my lord, the candidate has to disclose about his pending criminal cases, and he is also to disclose about his education qualification, etc.
In terms of 33A.
Yes. Thereafter, my lord, in the judgment of 2014-14 SCC, page 162, page 162, para 40 and 43, my lord. The Honorable Supreme Court made it clear that all this information regarding his education qualification, regarding his assets, regarding his assets of himself, spouse, dependents, everything for the first time in the judgment of Kishan Shankar Kathore, reported in 2014 SSC, page 162, para 40 and 43, has been incorporated, saying that Supreme Court is now saying that whatever is there in the act of the rules, but you have to disclose all these things. Then came, my lord, that resurgence case of 2014 SSC, page 189. There, my lord, for the first time in para 26, I have to refer to their judgment, my lord.
Yes, this is.
Second, there I have given one more volume today, my lord.
Okay, that is. You have given one more volume
My lord.
or books
One volume, my lord. Spiral binding.
to this code.
Huh? Oh. And then it photo card this one did. No.
Then books are not required.
No.
If it is there, then.
Huh.
Okay, you will come to that later on
Fine.
when it is referred.
My lord.
Yes.
But then came this resurgence that is not there. You will also not find there. Resurgence is reported in 2014. Not may kindly take a note, my lord. 2014 SCC
189.
189. Para 21.
21 or 26.
2014, volume 14 SSC, page 189.
Paragraph
Paragraph 21, my lord.
21.
Yes. For this, my lord, I was initially not thinking of not referring, but then I think it's important. That's why I'm referring to this, my lord.
Paragraph 20.
Para 21. Because in this judgment, for the first time, my lord, the Honorable Supreme Court has said that if information required in Form 26 is not furnished, it amounts to a, my lord,
Yes.
At this juncture, it is vital to refer to section 125A of the RP Act. As an outcome, the act of failure on the part of the candidate to furnish relevant information as mandated by section 33A of the RP Act will result in prosecution of the candidate. Hence, filing of affidavit with hit by section 125A1 of the RP Act. However, as the nomination paper itself is rejected by the returning officer, we find no reason why the candidate must again be penalized for the same act by prosecuting him. So in that particular case, say, but then it becomes a criminal offense. For the first time, it is indicated in this manner only, my lord.
Do you want to say
My lord.
that this proposition
Ma'am.
of filling blank and
Ma'am.
all
My lord.
cannot come within the ambit of corrupt practices or under any of the provision?
No.
Yeah.
I'm giving this background just to say how the law has developed, my lord.
Okay.
Because otherwise I could have abruptly, my lord, gone to the particular decision which says that even if this information details are not submitted, it doesn't amount to non-disclosure of material information and therefore no corrupt practice and therefore not invalid. I could have gone to the judgment straight away. I'm just giving the manner in which the election law in respect of this Form 26 affidavit has developed. Thereafter after this, my lord, resurgence came the Krishnamurti's judgment, my lord. This is the case where for the first time, my lord, Krishnamurti I have given, my lord, copy.
Citation?
Citation, my lord, I have given in the volume, lords will find. This is 2015, 3 SCC,
Then
467,
467.
para 66 and 91, I'm relying.
This is in which volume?
This is in the second volume,
The new volume.
my lord. And
Page?
I have given an index also.
Ah.
Page number is also given, my lord.
Okay, this is the
Krishnamurti, page 216, my lord.
216.
My lord, lords may kindly take a note, page 256, 58.
Just a minute.
Yes, space.
At page 258, lords will find this paragraph 66. One paragraph.
Page.
Page 258. 258. 91 to paragraph. Page human.
Yes, 258, pagination by yourself.
Yes.
Yes.
Page para 66, mine.
Yes.
We have already referred to the facet of undue influence in some decisions of this court. Emphasis has been laid by C. so amicus on influence on the mind of the voter that interferes with the free exercise of the electoral right and how such a non-disclosure or suppression of fact can be calculated to act to interfere with such right. The undue influence, as has been mentioned under section 123(3), uses the word direct or indirect. The court has drawn distinction between legitimate canvassing and compulsion on the electorate. Emphasis has been given on the ingenuity of the human mind, which is unlimited, and how the nature of interference can be unlimited. The ostensibility of the ground has been taken into consideration. In this context, we think it apt to reproduce section 171C IPC that deals with undue influence. This we can skip, my lord. Then, lordship may kindly see para 91.
Page.
271, my lord. This is the paragraph, my lord.
Yes.
The purpose of referring to the instructions of the Election Commission is that the affidavit sworn by the candidate has to be put in public domain so that the electorate can know. If they know the half-truth as submits so, it is more dangerous, for the electorate is denied by the information which is within the special knowledge of the candidate. When something within special knowledge is not disclosed, it tantamounts to fraud, as has been held in so. While filing the nomination form, if the requisite information as has been highlighted by us relating to criminal antecedents is not given, indubitably there is an attempt to suppress, effort to misguide and keep the people in dark. This attempt undeniably and undisputedly is undue influence and therefore amounts to corrupt practice. First time around in this judgment, the Supreme Court has very clearly spelled that, see, if you do not disclose, it amounts to corrupt practice under 122, 123 my lord, of the RP Act. Then, while summarizing my lord, in the judgment itself, at last page, my lord, page 173, from paragraph 94 onwards, in view of the above, page 272, my lord, in view of the above, we would like to sum up our conclusions. Disclosure of criminal antecedents of candidate.
Paragraph
Para 94, 94.1, then 94.2. And here, my lord, ultimately declared, saying that if you do not disclose, my lord, courts were very particular about the criminal antecedents particularly, and also the assets and liabilities. A person doesn't disclose the assets and liabilities, it amounts to undue influence. 94.4, Lordship may kindly see, as the candidate has a special knowledge of the pending cases where cognizance has been taken or charges have been framed, and there is a non-disclosure on this part, it would amount to undue influence, and therefore election is to be declared null and void by the election tribunal under section 101B of the 1951 Act for a practice. This is the position. Now, coming to the basic objection raised in the election petition, as I have noted, my lord, there are certain omissions, but which will not go in my humble submission to the root of the matter, for the simple reason that there is a disclosure, but then some details have not been given, like weight, etc., etc. But then when the purpose, I'll read this judgment to show, my lord, the purpose is to.
Which judgment you are reading now?
Now I'll be referring
That
to.
same judgment.
No, madam. I'm just making my submission first. And what I'm submitting before Lordship is, the purpose of bringing the law requiring a candidate to submit a Form 26 along with the nomination paper and to disclose the information is to entitle the candidate to know about entitle the voter to know about the candidate and full details of the candidate, so that he is not deprived of his fundamental right guaranteed under Article 19(1)(a), and he is informed fully so that he can take a considered decision as to for whom he is voting. A person who has got huge property but is not disclosing, that means the person is being deprived of his right to know, and at the same time he is trying to influence him by not disclosing his actual status to the voter. And that is why the Supreme Court has made, from the judgment of that ADR's case itself, my lord, that see, it is his fundamental right. If you do not disclose, means you are actually directly or indirectly interfering with his right to vote. And here is a case, my lord, in the election petition, there is no allegation nor is there any material to show that any vital information has not been disclosed. Some details have not been given, somewhere total is not calculated or mentioned, but otherwise, so far as criminal antecedents is concerned, he doesn't have any criminal antecedents, no criminal case pending against him, no conviction, and accordingly we have said no. So far as education qualification is given, we have given in one place, maybe in another place we have not mentioned, but then we have clearly mentioned from which university we have passed, what we have passed. So far as other movable properties are concerned, my lord, we have already given all information about the movable properties, but somewhere maybe the value of the vehicle or something, the date, something small. His right has been fulfilled by giving all the information, but some details which are not very important, which are not very material. I use the word material because on the Supreme Court has used the word material. No material information has been suppressed and no fraud has been played with the voters. And therefore, my lord, it cannot be said that the nomination papers submitted by the returned candidate is invalid. And there is no question of therefore any corrupt practice on his part. And as your lordship has seen, so far as the other allegations concerned, that one MP has given some appeal to the government officials that they should. So that allegation, as I have said, my lord, doesn't come within the purview of the requirement of law which says that you have to, if it is by some other person, you have to give that, you have to allege that consent has been, how the consent, where the consent was taken, and you do not have any allegation that any consent was given by him to the MP that she kindly appeal for me. So that being the position, my lord, my humble submission is on the facts of the case, it is not a case where there has been an invalid submission of nomination paper, much less any prior practice. All the recorded information has been given. Nowhere it has been mentioned that some information we have, my lord, suppressed. So that being the position, my lord, this is a case where your lordship will interfere because this doesn't disclose any cause of action. Order 7, Rule 11 is lordship is aware. I'm just reading for a moment since I have filed the application under Order 7, Rule 11. It says, my lord, rejection of plaint. And section 87 of the RP Act, my lord, says that as far as may be, the provisions of civil procedure code will apply. Order 7, Rule 11 says, when rejection of plaint, the plaint shall be rejected in the following cases where it doesn't disclose a cause of action. And other things, my lord, I am not referring. Now, my lord, in the bigger volume that I have given about containing certain judgments, my lord, a few paragraphs I'll read. My lord, paragraphs I have not indicated here. Right now I'll indicate what to make it take a note. So far as that Azhar Hussain versus Rajiv Gandhi's case is concerned, reported in 1986, supplementary SSC, this we have given to the other side also. Para 4, 12, 14, 40. I am relying, my lord. Para 4 is the important, my lord. Page 4 of this paper book, my lord. What is an election has been defined here. Lordship has got, my lord. In a democratic polity, election is the mechanism devised to mirror the true wishes and the will of the people in the matter of choosing their political managers and their representatives who are supposed to echo their views and represent their interest in the legislature. The results of the election are subject to judicial scrutiny and control only with an eye on two ends. First, to ascertain that the true will of the people is reflected in the results, and second, to secure that only the persons who are eligible and qualified under the Constitution obtain the representation. In other words, in order that the true will is ascertained, the courts will step in to protect and safeguard the purity of elections. For if corrupt practices have influenced the result or the electorate has been a victim of fraud or deception or compulsion or any essential matter, the will of the people as recorded in their votes is not the free and true will exercised intelligently by deliberate choice. It is not the will of the people in the true sense at all. And the courts would therefore, it stands to reason, be justified in setting aside the election in accordance with law if the corrupt practices are established. So also when the essential qualifications for eligibility demanded by the constitutional requirements are not fulfilled, the fact that the successful candidate is the true choice of the people is a consideration which is totally irrelevant, notwithstanding the fact that it would be virtually impossible to reenact the elections and reascertain the wishes of the people at the fresh elections, the time scenario having changed. And also notwithstanding the fact that elections involve considerable expenditure of public revenue, not to speak of private funds, and result in loss of public time, and accordingly there would be good reason for not setting at naught the election which the people lightly. In matters of election, the will of the people must prevail and courts would be understandably extremely slow to set at naught the will of the people truly and freely exercised. If courts were to do otherwise, the courts would be pitting their will against the will of the people, or countermanding the choice of the people without any object, aim, or purpose. But where corrupt practices are established, the result of the election doesn't echo the true voice of the people. The courts would not then be deterred by the aforesaid considerations which in the corruption scenario lose relevance. Such would be the approach of the court in an election matter where corrupt practice is established. But what should happen when the materials and particulars of the alleged corrupt practice particulars are not furnished and the petition does not disclose a cause of action which the returned candidate can, under the law, be called upon to answer? The High Court has given the answer that it must be summarily dismissed. The appellant has challenged the validity of the view taken by the High Court. So this is reflected, my lord. Then, my lord, para 8,
12.
8, my lord. From para 8, my lord, the provisions of Order 6, Rule 16, because there was an application under Order 6, Rule 16, along with Order 7, Rule 11. This we can skip, my lord. Para 12 is there, my lord. Para 12 is important. Learned counsel of the petition has next argued that in any event, powers to reject an election petition summarily under the provisions of the CPC should not be exercised at threshold. This was the argument, my lord. Now, Lordship may kindly see para 40. Which one? At page 23, madam.
Yes.
23. Counsel for the appellant has taken exception to the fact that the High Court has dismissed the election petition in exercise of powers under Order 711 of the Code of Civil Procedure, notwithstanding the fact that under said provision, if the petition does not disclose a cause of action, it can only be rejected and not dismissed. The contention urged by the learned counsel would have had some significance if the impugned order was passed before the this we can possibly skip it. It was in a different context because it was filed on the last day. Then the court was concerned with the question whether it should be rejected or dismissed. So, my fact remains that this judgment I am relying for the purpose of showing what is the election and what will be the consequence.
In paragraph 11, I think you will rely.
Yes, yes.
Paragraph 11.
My lord. Then, Lordship may kindly turn to the next judgment straightway, my lord. It starts from page 26. There I am relying on only one paragraph at paragraph 32 at page 45. This I am referring in the
Paragraph 39.
32, my lord,
32.
at page 48. This paragraph has dealt with the fact that when a person who has got only minimum number of votes but still challenges for the purpose of challenging, how the Supreme Court has dealt with it, man. Para 32. Before we close, we would like to express our anxiety on a feature which of late has assumed great proportion. In parliamentary form of democracy, political parties play a vital role and occasionally they sponsor candidates for the election. But under the existing law, it is open to any elector to contest election from any parliamentary constituency in the country, and it is not necessary that the candidate should be sponsored by a political party. It is permissible for an elector to contest election on his own as an independent candidate. Some independent individuals contest election genuinely, and some of them have succeeded also. But experience has shown that a large number of independent candidates contest the election for the mere sake of contesting with a view to make out grounds for challenging the election. Presence of a number of independent candidates results in confusion for the millions of the illiterate and ignorant electors who exercise their electoral right on the basis of symbols printed on the ballot papers. The presence of large number of independent candidates makes the ballot paper of unimaginable size, and ordinary elector is confused in the election booth while exercising their franchise. This leads to confusion. In the instant case, out of 14 candidates who contested the election, 11 of them, including the appellant, contested as independent candidates, and they all polled only paltry number of votes. This shows the genuineness of the candidature of independent candidate. The appellant is a resident of Gwalior in MP and he is a lawyer by profession. He contested the election as an independent candidate, and on the date of filing of nomination paper, He insisted on filing his nomination paper by stripping himself off completely and by putting on only a langot. This caused very consternation in the office of the returning officer, and it has also been raised as a ground of attack in the election petition. In fact, the appellant has filed certain photographs before us showing himself in a langot only. When this appeal came up for hearing before us, the appellant insisted that he should be allowed to argue the case by putting on a crown, an artificial one on his head. According to him, without the crown, he would not be able to make his submissions in a satisfactory manner. We refuse to grant permission to the great satisfaction of the appellant. A court of law is a solemn place where proceedings are held in a solemn manner. And the time of the court, especially in the apex court, is precious time which belongs to the people, and it would be wholly obnoxious to judicial propriety to allow a litigant to appear in court wearing a crown to argue the case. The court cannot be converted into a dramatic or theatrical stage. Well, this is the view taken by the
That
Supreme Court.
infamous person.
My lord.
He contested the election against almost all. All the.
Yes, your lordship is aware of that. Then my next is my lord, page 66.
Page 66.
My lord, here I am replying only one paragraph. There is para 5 at page 58. Lordship may kindly take the note.
You are coming to the
Lakshmi Narayan.
2023.
My-
No, Senthil Bala. No. Lakshmi.
Yes.
Huh? Which one?
This is page
Serial number 6.
my lord.
That is Kariko.
No, my lord.
Kri.
Page 51.
That is
Lakshmi Narayan.
Lakshmi Narayan Nayak.
Lakshmi Narayan, yes. Para 5 at page 58.
It starts at 51.
Yes, ma'am. Para 5 at page 58 is the relevant panel. Page 55, sorry.
Yes, I think 55.
5, I'm sorry.
Uh-huh.
I have wrongly written. This court in a catena of decisions has laid down the principles as to the nature of pleadings in election cases, the sum and substance of which being the pleadings of the election petitioner in this petition should be absolutely precise and clear, containing all necessary details and particulars as required by law. The allegations in the election petition should not be vague, general in nature, or lacking of materials, or frivolous or vexatious, because the court is empowered at any stage of the proceedings to strike down or delete pleadings which are suffering from such vices as not raising any tribal issue. That's all, ma'am. That Senthil Balaji at page 66. Lordship may kindly take a note.
Paragraph?
I'm relying on paragraph 15 and 17 at page 72 and 74. Yes. 72, it starts from 72. Page 72, my lord, para 15. Relying on that Achyutanandan, the judgment, my lord. Then the lordship may turn to page 73. After these bold letters, my lord, election petition was not liable to be dismissed in limine merely because full particulars of what parties alleged were not set out. It is therefore evident that material facts are such primary facts which must be proved at the trial by a party to establish existence of a cause of action. Whether in an election petition a particular fact is a material fact or not, and as such required to be pleaded, is a question which depends on the nature of the charge leveled, the ground relied on, and in the light of the special circumstances. Then next paragraph after the bold letters. Particulars, on the other hand, are details of the case set up by the party. Material particulars within the contemplation of clause B of section 83(1) would therefore mean all the details which are necessary to amplify, refine, and embellish the material facts already pleaded in the petition in compliance with the requirements of clause A. Particulars serve the purpose of furnishing touches to the basic contours of a picture already drawn to make it full, more detailed, and more imperative. Then 2 lines from this para 16, my lord. The consensus of judicial opinion is that the failure for practice is fatal to the election petition. The material facts are the primary facts which must be proved on trial by a party to establish the existence of a cause of action. Then, my lord, para 17. Here, my lord, this Dhartipakar Madanlal Agarwal's case has been relied. And at para 75, my lord, what you will find,
Para 75 or
para 74, the paragraph 17 starts on which I am relying, my lord.
page,
Page 74,
paragraph 17.
17.
Yes.
Para 13 of Dhartipakar has been relied on. And then, my lord, this page 75, what you will find.
This court.
No, my lord, I'm just relying the last 3 lines from the last part of para 17 above paragraph 18 at page 75.
Yeah, present. Okay.
The emphasis of law is to avoid a fishing and roving inquiry. It is therefore necessary for the court to scrutinize the pleadings relating to corrupt practice in a strict manner. Next is, my lord, that
Just
cunning. Now, next is that Kanimuji famous lady's judgment, my lord.
78.
Page 78.
Which paragraph?
Para 20, 21, 25, and 26. Which your lordship will find it from page 86 onwards, my lord. ATC my para 20 starts in a very interesting and important decision in the case of Union versus Association for Democratic Reforms. A 3-judge bench of this court raising a question in a nation weighted to Republican and Democratic form of government, whether before casting votes, the voters have a right to know relevant particulars of their candidates contesting election to the parliament or to the legislature of states, deliberated on the part of the Election Commission under Article 324 of the Constitution and observed as under. This I have already referred, my. Then para 21 at page 87, Lordship, you kindly see. It is apparent. It is also apparent to note that insertion
21 paragraph.
Para 21.
It is pertinent to note.
Yes. That the insertion of Rule 4A and Form 26 appended to the said rules is also culmination of the said observations made this court in aforesaid case, which required the candidate to disclose the information and particulars in the form of affidavit to be submitted along with the nomination paper. Then para 25 and 26. You will also find page 89 and 91. Page 89, para 25, my lord. I am straightway referring to the para. Now it is no doubt that true that all material facts have to be set out in the election petition. If material facts are not stated in a plaint or a petition, the same is liable to be dismissed on that ground alone, as the case will be covered by clause A of Rule 11 of Order 7 of the court. Then next page, my lord, page 90, para 26. Just a few lines. That in judgment of Anil Vasudev Salgaonkar, in para 50, Lord, you can see the position is well settled.
Which
That page 90,
90.
my lord. After para 26, my lord.
Just a minute.
Para 26, that para 50 of Anil Vasudev Salgaonkar, my lord. The position is well settled that an election petition can be summarily dismissed if it does not furnish the cause of action in exercise of the power under the Code of Civil Procedure. Then again, next paragraph, para 51. This court in Samant and Balakrishnan case has expressed itself in no uncertain terms that the omission of a single material fact would lead to an incomplete cause of action, and that an election petition without the material facts relating to corrupt is not an election petition at all. Then, my lord, I am going to the next judgment, recent judgment from our High Court, page 101.
Paragraph.
Para 38 to 44, my lord. 49 and this is the para 38 to 44 and 49. page 131, Lordship will find para 38.
131.
31. This will be of relevance for our case.
Page 131, paragraph 38.
Yes. In the affidavit in Form 26, Kariko Cree was required to state as to whether he had been in occupation of the accommodation provided by the government at any time during the last 10 years before the date of notification of the current election, and if so, he was to furnish a declaration to the effect that there were no dues payable with respect to the said accommodation in relation to rent, electricity charges, water charges, and telephone charges. Kariko Cree, however, failed to disclose the fact that he had been in occupation of the government accommodation during his tenure as an MLA between 2009 and 2014. He stated not applicable. However, with regard to the declaration as to there being no dues, he mentioned the date of so-and-so and stated that dues in respect of rent, electricity charges, water charges, and telephone charges were nil. After so-and-so raised an objection to this candidate on this ground, Kariko Cree filed the requisite no due certificate of 2014. However, the High Court was of the opinion that the failure of the Kariko Cree to disclose the factum of his occupying government accommodation from 2009 to 14 and his failure to submit the no due certificate in relation to such government accommodation was sufficient in itself to infer that his nomination paper was defective, and in consequence, the acceptance thereof by the returning officer was improper. Having considered the issue, we are of the firm view that every defect in the nomination cannot straightway be termed to be of such character as to render its acceptance improper, and each case would have to be turned on its own individual facts insofar as that aspect is concerned. The case law on the subject also manifests that this court has always drawn a distinction between non-disclosure of substantial issues as opposed to insubstantial issues, which may not impact one's candidature or the result of an election. The very fact that Section 36(4) of the Act of 1951 speaks of the returning officer not rejecting the nomination unless he is of the opinion that the defect is of a substantial nature demonstrates that this distinction must always be kept in mind, and there is no absolute mandate that every non-disclosure, irrespective of its gravity and impact, and this is what I was saying, would automatically amount to defect of substantial nature, thereby materially affecting the result of election or amounting to undue influence so as to qualify as a corrupt practice. The decision of this court in Kishan Katur Supra also demonstrates this principle, as this court undertook examination of several individual defects in the nomination of the returned candidate and found that some of them were actually insubstantial in character. This court noted that two factors required consideration: whether there is a substantial compliance in disclosure requiring information in the affidavits filed along with nomination, and whether non-disclosure of information on identified aspects materially affect the result of election. This court observed that on facts that non-disclosure of the electricity dues in that case was not a serious lapse, despite the fact that there were dues outstanding, as there was a bona fide dispute about the same. The rest we can skip, my lord. And then, my lord, the down below of this paragraph itself. Earlier in Sambhu Prasad Sharma versus so, this court observed that the form of the nomination paper is not considered sacrosanct, and what is to be seen is whether there is substantial compliance with the requirement as to form, and every departure from the prescribed format cannot therefore be made a ground for rejection of the nomination paper. In the case on hand, it is not in dispute that there were no actual outstanding dues payable by Kariko Cree in relation to government accommodation occupied by him earlier. His failure in disclosing the fact that he had occupied such accommodation and in filing the no due certificate in that regard with his nomination form cannot be said to be a defect of any real import. More so as he did submit the relevant documents of 2014 after Nune Tayang raised an objection before the returning officer. His explanation that he submitted such certificates in the year 2014 when he stood for election as an MLA is logical and worthy of acceptance. The most important aspect to be noted is that there were no actual dues, and the failure of the Kariko Cree to disclose that he had been in occupation of government accommodation during so cannot be treated as a defect that is of substantial character so as to taint his nomination and render his acceptance improper. And then 44 is of some importance.
This was a final election petition, isn't it?
Yes, final.
It is a final.
After
decision.
final disposal.
But there is a judgment from here where order 7 rule 11.
I have the next is that.
Okay.
But incidentally, I appeared in both the cases.
Hmm.
In the other case, my order 7 rule 11 was petition filed by the return candidate was rejected. But when the matter went to Supreme Court,
So
my lord,
Supreme Court allowed it. So on that ground, it was decision. I think by Harley DC Trivedi.
yes,
Trivedi's
yes.
judgment.
And Aniruddha Bose of now he has retired on justice.
National Judicial Commission.
But my lord, I have got my own reservation about their judgment. But once there is a judgment, I have to accept it. I went twice, my lord, to take part in the argument, but on those both these dates, matter didn't reach, and I could not place. But there is a fine line. That line was somehow anyway. Well, we have to accept that judgment in whatever form it is today. At an appropriate time, maybe I'll be getting a chance. Well, para 44 at page 135 is of some relevance. 34 प्रारंभ होइसे.
I have read all those paragraphs.
My lord.
In the meantime.
My lord. So
This is difficulty on my part.
you're
I
very
go a
fast,
little
my lord.
bit fast page 44, 45.
And one thing I'll just indicate here.
Then
This-
45 last part, isn't it?
Yes, yes, absolutely correct. Well, this judgment
That
of
mere non-compliance, and this is practically what is the effect on the return candidate
yes,
or materially
materially
affected.
affected.
That may not be at this stage, will be.
My lord, here is a case where we say that there has been substantial compliance with the requirement. of
That argument we understand, but
Yes.
so far relating to material effect and all,
Well,
will
that-
it be appropriate
My
to
lord, not your lordship is absolutely correct. My lord. Your
deal
lordship is-
to those
yes,
issues at this stage?
possibly.
I do not think so.
No. my lord. In other cases, yes. Because in other cases where there is a substantial defect,
Huh.
then the question of arguing the next point will come whether it is actually.
No,
materially affected
that
or
will be
not.
different, but
Definitely.
here basically 26A,
Yes,
your whole argument will be yes.
yes.
In certain aspects,
There are
what has been
omissions.
pleaded,
There are small,
that is
small omissions.
admittedly, if we will go by there is no defect.
Yes.
In certain, yes, there was non-disclosure of certain things, but if we read as a whole, that has already been disclosed.
Disclosed.
Maybe one part was not disclosed, so
Yes.
that will not deprive the citizen from
Of their
knowing
right
the
to know,
candidate,
yes.
and therefore it will not result in a corrupt
Correct.
practice.
That is my
As
point.
well. This
That
is
is-
your
that
argument.
is my- My lord, I'm just indicating one thing. Page 101, lordship may kindly take note of one thing. I have not given any citation here, but this has been reported in AIR, my lord. So that citation, lordship may kindly
101.
101.
What is
This
this?
is AIR 2024,
AIR
2024
2024
SC
SC
2121.
2121.
And the next is at page 143, which your lordship is referring to, Karimuddin Barmiya versus Aminul Laskar. 143, my lord. And this is also reported in AIR
Just a minute.
143.
143. AIR
AIR 2024
2024
SC
SC
2193.
2193.
I'm relying on para 17 to 24. Starting from
Paragraph
17 to 24. Starting from page 156. That's 17. Para 17 onwards, this allegation was that the affidavit in Form 26 was not filled up.
Where do you get that?
Para 17 at page 156.
Huh.
And in this he had also through a partnership firm, he had a liability of not paying provident fund, employees provident fund. And thirdly, he has annexed a document that he has passed BA, and we inquired from the concerned university in Meerut because I appeared in that case when I remember, mirrored, and he said he passed BA. We have brought information that he never studied in that university.
So according to you, those materials were available
Yes.
in the pleading.
Yes.
Despite that says there's no.
My lord. Your lordship will read the judgment, and what I cannot submit, my lord, because we have to accept 141. Lordship will realize, my lord. But for this case, my lord, I am straightway coming to page 164, para 24, my lord.
Okay. Just
As-
just a minute, just a minute.
Let me note it.
Para 24,
My lord.
page 164.
My lord, before that, I'm just, what I was saying is, I'm just pointing out one thing, page 163.
163. Yes.
Para 23. The finding is, as transpiring from the election petition, the respondent number 1 himself had not raised any objection in writing against the nomination filed by the appellant at the time of scrutiny made by the returning officer under section 36 of the Act. According to him, he had raised oral objection with regard to the education qualifications stated by the appellant in affidavit in Form 26. If he could make oral objection, he could as well have made an objection in writing against the acceptance of nomination of the appellant. And in that case, the returning officer would have decided his objection under subsection so and so after holding a summary inquiry. Even if it is accepted that he had raised an oral objection with regard to the education qualification of the appellant before the returning officer at the time of scrutiny, the respondent number 1 has failed to make averment in the election petition as to how appellant's nomination was liable to be rejected by the returning officer on the ground mentioned in section 36 of the Act, so as to make his case fall under clause D1 of section 101 that there was an improper acceptance of nomination of the appellant. And this goes, in my humble submission, contrary to the judgments where, my lord, the Honorable Supreme Court is very clearly saying that you have to disclose about your education qualification. And so far as this objection is concerned, my lord, Supreme Court has in at least 2 cases said that even if no objection was raised at the time of, my lord, scrutiny, I can always file an election petition, and that will be a matter of trial. But anyway, my lord, this judgment we have to have.
But here he has filed objection.
Yes, yes. And I'm not raising that plea.
That's for understanding.
Yes. Para 24, well, I'm just referring last paragraph. As stated earlier, in election petition, the pleadings have to be precise, specific, and unambiguous. If allegations contained in the election petition do not set out grounds as contemplated in section 100 and do not conform to the requirement of section 81 and 83 of the Act, the election petition is liable to be rejected under Order 7, Rule 11 CPC. An omission of a single material fact leading to an incomplete cause of action or omission to contain a concise statement of material facts on which the election petition relies for establishing a cause of action would entail the rejection of election petition under so-and-so, read with so-and-so. So here is a case, my lord, where they have, the petitioner has shown certain omissions here and there, but then information as a whole is there. Maybe in some column it is not, weight is not given, but then jewelry, etc. has been given, price and value is given. So these allegations will not per se deprive the voter of their fundamental right to know about the candidate, and that is my argument.
And that will, in view of that proposition, affidavit is accepted as a cannot be said on the face of it to be an corrupt practice, therefore, it is bound to fail. This is
Only one thing I'm showing from the section 36, my lord. This I did not show actually. 36 speaks about scrutiny, and 36(4) says, no, 38. No.
yes, what it says.
Well, 36, section 36, subsection 4 says, the defect has to be substantial in order to reject the nomination paper. Section 36(4). The returning officer shall not reject any nomination paper on the ground of any defect which is not of a substantial character. So in my humble submission, my lord, even if some defects have been pointed out, these are not of substantial character. That is my submission. and therefore the returning officer was right in not rejecting my nomination paper. That's my submission.
Yes.
Well, and my lord, in that judgment, I have not read all these paragraphs. That Azharuddin's case, my lord, the Supreme Court has said the swords of Democal should not be allowed to be hovering over my head, my lord, because ultimately this election petition is liable to fail. So if the trial continues, this will keep on hovering over my head, and I'll not be able to concentrate on my public duty.
Basically, they have given this. We were given candidate handbook. I have gone through the content of the candidate handbook, more particularly regarding the filing of nomination paper and affidavits. My lord, whatever we were told in the meeting is written handbook also. Is in the handbook, I think, candidate 2023. Candidate handbook 2023. My lord, during filing of the affidavits, that is Form 26, it was clearly reminded in notes the same things. Whatever the RO has given a speech, that has been also given in Form 26, clearly have mentioned there. My lord, Election Commission of India also regularly reminded this regard to all the chief electoral officer to circulate the same to all the district election officer of the state in this regard. So I have a paper here. Especially from 2013 and all these things, especially with all our, give it to her. I have given all these 13, 19, up to 19 and 23 also. Especially this filing of nomination papers. No columns should be left blank. Supreme Court also time to time in different rulings upheld and directed to fill up the nomination form properly and as number 1, applicant did not file up his nomination paper and affidavit as prescribed now. I have raised an objection during scrutiny also, verbally, and in writing also I have given. But the RO accepted all 3 nomination papers. Duly nomination papers of the respondent number 1. Hence, I have filed this case rejection of his nomination papers with prayer for direction for re-election. My lord, I have filed this election petition as per law. I have filed this election case when the returning officer, even after my written and verbal objection, accepted the nomination papers of the respondent number 1. Nomination papers were not filled up as per prescribed form. The affidavits and are also not filled up as per prescribed norm. It is evident from the annexer, that's all affidavit, and I have given this. My many columns were kept blank and no information furnished. Like the nomination paper filled in the previous election also. In 2014 also he have done like this, my lord. And 2019 also, and this time also. 2024. In this election also, the nomination papers were filled in violation of prescribed rule and regulation. That is my,
Yes.
so my objection is, my lord, is a specific, has,
No, your whole case is that when you do not disclose, it amounts to an corrupt practice, and there, and admittedly, he has not disclosed certain thing.
here also,
Yes.
this is from candidate handbook.
Hmm.
It's clearly written here,
Hmm.
whether all columns are filled up or not.
Hmm.
Yes or no, they have tried,
Hmm.
but nothing has been come out from my objection and all these things.
Hmm.
And regarding the storing of affidavit by executive magistrate,
Hmm.
here also, in form also, here also, it clearly has written here.
Hmm.
The affidavit shown before oath commissioner
Hmm.
or magistrate of first class
Hmm.
or before public notary.
Correct.
For this, they have submitted, my lord.
Hmm.
This is their documents, not my documents.
Hmm.
IA, in their IA, they have submitted. This is their document.
Just a minute, let me
Yeah,
say
they-
verse. Then
Page number 33.
of your petition is that
No, IA of their IA.
of their idea.
32A, 32 R32 R3, page number 32,
Hmm.
and page number 32.
Ah.
This is letter from Election Commission of India.
Hmm.
Specifically, this
Hmm.
judicial, may I read notification?
Hmm.
Judicial dash 50/2004,
Hmm.
part 1, dated 26/7/2023.
Hmm.
The commission has referred this letter.
Hmm.
This notification, for that we have no objection. This is just an NOC.
Hmm.
For so this, my lord, this is a copy of notification. May I read? May I allow to read, my lord?
Ah, yes, you read.
Here, specifically, the governor of Arunachal Pradesh.
Hmm. That notification,
Yeah.
that
This notification.
26/7/2023.
Yeah, this is their documents. They
Ah.
have furnished this,
Ah.
and they have furnished. This is of no use.
Hmm.
They have furnished one document, which is from this electoral officer, joint director.
Joint Election Commission. Ah.
That letter refers to,
22nd of March 2024.
yeah,
Yes.
that letter refers to,
You have the copy of that?
yeah, I have to carry. That letter refers to, this is their documents, it's not my documents.
Hmm.
This is letter they have referred.
Ah.
This letter specifically refers to,
26/7/2023.
no, 20, this letter is from Arunachal Pradesh.
Arunachal Pradesh is the,
This
it
letter-
refers to 22nd of March 2024.
Yeah, this letter refers to, my
Ah.
lord, this letter.
Show me that. This letter refers to this 22nd March, yes.
This letter refers to this letter,
26/7/2023.
and this letter refers to,
26/7/2023.
yeah, this letter refers to 26.
7/2023.
And this is
What is that verse?
here para.
Give us, give me.
May I order to read, my lord? The governor of Arunachal Pradesh,
Hmm.
the governor of Arunachal Pradesh further pleased to order that in the event of absence of public notary in the district of other than Itanagar also, and just above this para, the governor of Arunachal Pradesh is further pleased to order that in the districts and other such places where the public notary has not been appointed, list and close here.
Hmm.
as Annexer A. The executive magistrate of that area shall continue to verify, authenticate, certify, or attest such documents, affidavit, etc. So Changlang has got, my lord, 2 public notary. So on this ground, executive magistrate has no power to execute the sworn, the public, this affidavit. It is unauthorized, illegal, and unlawful. So in this ground, the IA or the affidavit and the nomination paper is liable to reject, my lord. It's my prayer.
Okay.
And it's there. This respondent number 1 does not have honor or respect of the board, this law or the court, honorable court. Here also they have submitted 1 documents, which is R1. Page number
28.
page number 28, Annexer R1. Here village 1 mile. There is no 1 mile in Changlang. As per record available with us, with me, or with I think this is it. The address given to the Election Commission of India in his nomination paper, it is different, and this is different. From itself, we can say that we can see these are, they doesn't have any regard for law. Clearly, this is written here 1 mile. And to negate this, I have the address given to us in his nomination paper is Kesam Pongte, son of Sri Kodong Pongte, village Laktong, residents of Laktong. Nowhere he has mentioned that 1 mile, but they have done this. This is self-representation. Evident. My lord, I have the mention that the MP sitting regarding sitting MP. May I play 1 video?
No, that cannot be.
Otherwise, I have reproduced here what he has said.
That is there.
That I will read out.
You read it.
कुनुबाई गवर्नमेंट ऑफिसर है डायरेक्टली और इनडायरेक्टली हमारा रूलिंग सरकार का कैंडिडेट का विरोध में है तो हमको एसएमएस कीजिए, सीएम साहब बोला है। आज तक 4 ऑफिसर शायद सस्पेंशन हो गया होगा, ऐसा लग रहा है। 4 ऑफिसर सस्पेंशन हो गया होगा ऐसा लग रहा है। तो यहाँ गवर्नमेंट ऑफिसर गवर्नमेंट का साथ देना है, ये मैसेज भी आप लोग बोल दीजिए। जिमान गांबुरा असे जिमान ग्राम मेंबर असे बीजेपी के सपोर्ट करो। This is an extract of his speech that during election campaign. That was also at Changlang.
See what he is saying is that
This is an, I think,
this is you have stated that the declaration
Yeah.
is given.
Yeah.
What his argument will consider all this.
yeah.
But his argument is that it is said by Chief Minister
Yeah.
and the Member of Parliament,
Yeah,
is not it?
yeah.
Threatening the officers not to object and
Ah,
voters give vote for the ruling party.
My lord, this is physical treatment,
it-
external.
Uh.
That arrow might be have an internal threatening,
No.
whatever
See,
he may be.
that is what I'm saying.
That's why he has not rejected that nomination paper. That is the ground, what I mean to say.
Yes.
Otherwise, it is there ample example to reject
Okay,
this
so what
nomination
you
paper.
propose to say is, in view of such threat
Yeah,
by the MP
Yeah.
and the chief minister, the election officer out of fear has not rejected the nomination paper, though it is a clearly illegal and it was in violation of the
of
rule.
the Supreme Court,
Order
Supreme
and
Court's
the-
order.
Okay, take a note of.
That is my
Yes.
prayer.
Yes.
And during scrutiny also, I have requested him, such and such things. Kindly you go to
You have
this.
filed that application, that is part
Yeah.
of this.
Here in page number, I have given in my affidavit and, yeah,
It is part of your election petition also.
yeah.
Yes, that is.
My election petition is specifically regarding this and the executive magistrate and fill in the blanks. The blank he has kept in his, he has given asset or not, that doesn't matter. But the column he has left blank. That was my question. Is it as per the norms or not? That is my question. He has fill up or not, that doesn't, I have not raised any question about that, but they have, yes. This is their documents, whatever I have raised here. So this is my prayer, my Lord. I have come here, that there is specific act for any election petition. So this should be hearing that provision of law, and as per existing whatever that I know, I hope you understand. That is my objection. And I come here to seek justice. Justice may prevail, and there I may reject with I may be reject with heavy post. And what they have, these are all are their documents, my lord.
Yes, yes.
The annexure D,
Hmm.
annexure they have mentioned about annexure D. It is also, and I think, illegal. I have got it from election website, election commission. Nomination was submitted, but affidavit not received. Affidavit was not received till 7.
This is a part of your election petition?
Yeah,
Which page?
on 26.
Which page?
This is I have given in page number 278, annexure D.
278 of
Yeah.
your election petition?
Yeah, not petition, this one, my affidavit. and-
Reply.
Yeah, reply.
This is, he has submitted evidence on affidavit.
Yeah, this evidence and affidavit.
Evidence and affidavit file means
File.
already filed. You cannot file that anyway.
They also have mentioned.
Evidence and affidavit, you have not filed written statement. that is-
No.
No, I have also, earlier also I have given this. Earlier also.
So you have filed the election petition.
Yeah.
Is that document a part of the election petition?
Yeah.
Where is that? Which page?
Page 36.
Page?
Page 36 of that. Page 36. Annexure D.
Okay.
Affidavit not submitted. Yeah.
Page 36. Okay. (7:20 PM) of which date?
26 March 2024.
How do you get that? Application uploaded 26. What was the last date?
Last date 27.
Okay.
He has, respondent one has submitted nomination paper on 26, that I accept, but it was not accompanied.
On that date, affidavit was not accompanied and it was subsequently uploaded. When?
27.
27 was last date.
Yeah, this is not the last date. And with some rectification, some changes he has done here. That means RO has informed him you have submitted such and such defect.
Okay, now I understand.
Affidavit. So we rectify it.
He has corrected it and they are.
He has corrected it.
Had he filed in that manner, that his nomination would have been. Sir, Ayo has given him a chance, then also he has
He
committed.
has not corrected that one.
Okay.
What I said, that was, after that also, he was given a sufficient time.
Hmm.
After
But
that
still,
also,
he failed.
yeah, he still failed to submit a correct nomination paper and affidavit. So this shows that this respondent number one is a violator of law and does not have any respect to the law.
How many respondents are here?
Respondent for two.
The petitioner, the elected
Two other-
candidate
two
and
other. We have four candidates.
four candidates.
Yeah. Respondent two has come, but he has not.
Okay. That's all?
No, my lord.
You want to add anything?
Yeah.
Yes.
And here, I hope you have gone through their IA. Their IA, they have not replied my queries. Just they have lingering and valuable time of court has been spent, waste of time. So, my lord, my petition, my prayer before is that I have already given all my evidence, affidavit in opposition and written and exhibit all this here. And with this in Changlang district, two notaries were duly appointed. And on that very day, they were present to negate that I have shown these are the affidavits. One is shown at 26. That means this person was not in leave.
Is it part of your
Yeah,
objection?
part of my objection.
Objection,
So,
which page?
so that
So you have annexed all this in your objection?
during that time, this notary was present here. This is also done on 26. And this one respondent number 3 also was done at 22. That means it was present here. So this respondent number 1 is, I have already given his nomination papers and affidavits from 2014.
These documents is part of your objection or part of your evidence on affidavit?
So both.
Both. It
Yeah.
is in.
It is given.
Is it, he has filed that IA,
Yeah,
you have filed an objection.
Yeah.
These are part of your objection?
yeah.
Okay, then fine.
In 2009 also, 2014 also. His first election was 2014, yes, 4 years, but they have mentioned only 2017 and 24. This is also in what they may call bona fide error. They have given all this bona fide error. So I think whatever my objection is that, my lord, that keeping the column blank is a violation of
Challenging election petitions are two grounds.
yeah.
One is that election is influenced by the statement of the chief minister and the member of parliament,
that
which was published in newspaper. This is a corrupt practice. Okay.
yeah.
And second part is that there are many defects, not ticking, keeping the forms blank, under that form on
Is clearly
26. Therefore, that 26 itself is will amount to a corrupt practice in view of the Supreme Court judgment, and therefore this election is liable to be
my
interfered.
lord. For that here also.
Okay.
May I read out?
This is latest guideline when it was
This
issued?
is Resurgence India versus Election Commission of India. Others, Ranjana Prakash Desai and
That judgment
the candidate must take minimum effort to explicit remark as nil or not applicable or not known in the columns and not to leave the particular blank. Here clearly they have mentioned here, my lord. Okay.
Can you give that?
Yeah.
Just I'll mark it, no problem. 2013 CS research.
My lord, they have given one list of a book which is not relevant to my case.
Okay.
I have gone through this. There is no relevant. And my lord, my prayer is only once again, my prayer is that I have come here to seek justice and the whole material fact is crystal clear.
I'm keeping this, I'm returning it to you. Okay.
Crystal and clear. And this IA as well as their main petition is liable to reject and re-election maybe or the election of 2024 may be declared as void. With that, my okay.
Can you you have written note to me? That you have given, that you have read it?
Oh, okay, my lord, okay.
You give it?
This is just,
No problem, no problem. Whatever you, or you can do it, you can type it and give it tomorrow. Possible?
yeah, I will make it
You,
fair.
you make it fair and give it to her. Okay, but before 12 tomorrow.
Couple of minutes.
Yes, sir.
This notification of 26th of July 2023, which was not otherwise part of the election petition, now they have submitted in the evidence on affidavit. There, if you also just have a look at the document.
Yes.
In one paragraph, it says the governor of Andhra Pradesh is further pleased to order that in the event of absence of a notary public,
Just a minute. Just a minute. In the events of,
in the governor,
which paragraph you are reading?
the last part one, first page.
The governor of Odisha Pradesh is further pleased.
Pleased to order that in the event of absence of the notary public in the district, other than the Itanagar capital region, where a notary public has been appointed, as my notary was appointed, also the executive magistrate of the area shall continue to verify, authenticate, certificate, or attest such documents, affidavits, etc., during the period of his absence. So, if the allegation in the election petition is that at that relevant point of time, the notary public was not absent, in spite of that, they have the oath was administered by executive matter would have been different, but that no such allegation in the petition, election petition. So that will clinch the issue.
To support
So that not
there is two notary and after there are also CGM court is also there. What I mean to say is that this executive magistrate does not have authority.
So your case is that at that point of time, notification could not have been made applicable to Sanglang district as there were already two notaries or judicial magistrate is already there.
Moreover, my lord, this letter was served to deputy speaker also. At that time, this respondent number one, deputy speaker, he was deputy speaker. Deputy speaker is a constitutional body, which we supposed to be regard him as a savior of Constitution of India. Even after having that post, he is violating these things. That means that this respondent number one does not have honor the Supreme Court and law of the land. It does not have any regard to the law of the land. That is important.
And the other document is
And for that also, this copy was served to DC also, available with Deputy Commissioner.
That notification, is that it?
All the district judges also, there's SDM, ADC, ESD, all the sub-divisional officers were also served. This notice was served. Even after they're having these things, they are doing these things. It means that this is a habitual offender.
Yes.
And here, my lord, this document is the part of the petition. No. Yeah. No, this is evident.
No, no evidence. Someone,
My lord, I want to highlight this also. 2014 election, his nomination was just he make cut like this. This time also he has taken like this, but this is not available in the website, so I will not do. 14 also he has done like that. 19 also he has done like that. This shows he is an offender. He does not have any regard to the law and respect to this honor to the Supreme Court of India. Such mentality of people how they can start the society.
just a couple of instances. So far as this allegation that notary public was there is no ever.
Your argument is that whatsoever the material, this is not specifically
These are, my lord, not my documents. These are their documents. Whatever they have given. Election Commission, this undersecretary one, they has enclosed here. This is in reply of that, I have given this one. This was referred to this letter was referred to this letter. This letter referred to this
That's
letter.
I'm saying, I understood that. One is the Joint Election Commission refers to the document of the Election
Yeah,
Commission.
NOC,
Election Commission refers to the document of governor,
governor of
and the governor's document says according to you, when there is
yeah, man. And one more, my lord, I am very hard by the statement of this learned advocate. He has mentioned here that I am not a genuine person. So to you, I want to know, who am I? Who is the genuine Nyasam Jongsam that I want to know? This might be clear from this year. Otherwise, I have to serve notice, or my lord, kindly serve notice. What does the term genuine person? I have got my voter card. I have got my Aadhaar card. I have got my ST,
no, he said
PRC.
genuine-
Even after that, I have been
no,
termed
he
as
is not say
not a genuine.
person. He
No,
said genuine candidate. You want to say that you are not a genuine
that
candidate.
I don't know, but I have got here that genuine person. He is not a genuine person. That I want to know from you, my lord. This is my prayer. This should be, otherwise, this is not an very, in a law term, I don't know, but such terms, such words are termed as derogatory, slang language. So I want clarification, my lord, on this regard. Yes. Why he has termed me as a not genuine person.
Okay. You kindly please just give a note tomorrow.
Okay.
Okay. You prepare it, then give it tomorrow.
Oblige.
Then that will help me in recording your arguments.
Oblige, my lord.
What happened? What coming? Are they here? You know, so they have gone somewhere else. Huh?
My lord, may I allow to play this Tapurgao's video? It's available in social media. That's why I have got in my mobile also.
No, see, that's correct, but that will come at a different stage. That in a time of evidence, not at this stage. There are some procedure. That's why otherwise I would have gone through it, but this will come at a later stage. Okay, as a piece of evidence. I लिखिबो. IA 180 is not it. Hearing concluded, judgment reserved. Heard Mr. D. Mojumdar, learned counsel for the senior counsel for the applicant, assisted by Deuri.
SK Devi.
Deuri. And the election petitioner
In person.
slash opposite party in person. Full stop. Hearing concluded, judgment reserved. And in election petition, you write this, list this petition along with IA 180 and in IA 140, you write it down, interim order passed earlier shall continue till delivery of judgment in connected IA numbers. Mr. Mojumdar, there are some preoccupations almost till 18th of November.
No difficulty, madam. We have
Okay.
cited quite a few judgments, madam.
So this order will be after 18th of November
Obliged, madam.
because I have some other preoccupations,
No difficulty.
not the judicial but personal. So no, may not be. I'll try my level best. But moment you reach Guwahati from Monday, it's-
My lord, I have forgot to mention one thing also.
yes, then.
They have given in their IA
Hmm.
rival candidate Mr. Rentu Taizu, which is also a misinformation.
Hmm.
Rentu Taizu was not a rival candidate. It
Okay.
was Tinghap Taizu.
Okay.
who is the
You just,
last year.
if anything comes to your mind, even after going from here, you can put in your note. Okay?
Okay.
And give it. Yes, unlisted. This file will go, we have properly pack it up. But not all cases are CAVs, huh? Only one. Yes, what is this?
Your Honor, I mentioned this item in the morning. for
What
withdrawal.
is this? Tell us.
This criminal petition, Your Honor, was filed challenging the NBWA orders that was passed by the learned special judge NDPS Bomdila. And after NBWAs were issued to him, he was arrested on 8th
Just a minute.
April.
Please tell us what happened.
You know, the accused person, he was arrested on 8th of April 2024.
Accused was arrested on
8th of April 2024.
8/4/2024. Okay.
After he failed to appear before the trial court.
Okay.
Initially, he was granted bail by this honorable court on 31st.
Where do we get that?
It is there in the petition itself.
Give me the page. You are without the brief. Why?
Yes, Your Honor, it was only for withdrawal.
You want to withdraw this?
Yes, Your Honor.
Then why should we hearing it?
No,
The
Your
current
Honor,
con-
I
I thought
wanted
that
to-
some, you want some stay order.
Your Honor, it's for withdrawal. However, the matter is, it went out before the Honorable Chief Justice for reference. If Your Honor is aware, in between there was an issue that was raised with regard to whether the NSS will be applicable or CRPC will be applicable in cases which were already. Now, since the records are present here, I've been instructed that I withdraw the case from here and then submit the order to the Honorable Guwahati High Court, and then they would remove the matter from there.
Okay, learned counsel for the petitioner submits that she may be allowed to withdraw
Withdraw.
this application and file a fresh petition
Yes, Your Honor.
if so advised. Full stop. And oblique or to approach the learned trial court below.
No, Your Honor,
Not
filing,
necessary.
no, filing of fresh application itself, because
Filing
you're
of fresh-
challenging the NVW.
Filing of fresh application. Full stop. Prayer is not opposed accordingly. Same stance allowed with the liberty as prayed for. That's all.
Yes.
But whether it is under BNSS or CRPC, in either provision, the principles are same. We can
Yes,
consider.
Your Honor. After the cases were sent for reference, other matters are being dispersed.
Same.
Yes.
So we can, my view subject to what there is, at least this intervening period till decision is made, we'll treat it as a bail application or a recalling allegation. That should be, otherwise people will be inside jail.
Yes,
Anyway.
Your Honor. Okay.